Looking at criminal law, there's a couple different choices that the professor can make, the bar exam can make, and a lot of students have struggle with understanding why are we studying common law? Why are we studying all these different statutes? Why are we studying all these different options? How's this going to help me? How's this relate to what I need to know for the exam? So there's a couple different choices that the professor can make, a couple different choices that the bar exam can make. One choice is simple. We study the common law. Let's pick common law larceny. We learn its elements, taking and carrying away a property of another. And then the most important part that we learn from the common law that's developed over hundreds of years is the specific intent element with an intent to permanently deprive. So we read some cases, we learn about what that means, especially that specific intent element. And the choice that I may make as the professor, or the choice that the bar exam may make as the test giver on the exam is, we might give you a larceny statute and we might borrow directly from the common law. So one of the choices we make is you learn the common law, you have to memorize common law elements, and we take straight from it and adopt that as our statute. That's an easy decision, easy way to do it. And of course, that's a lot easier for the law student to understand. Why am I learning common law from hundreds of years ago? Because it might be the statute that a jurisdiction chooses, but it also might be the statute that, most importantly, your professor or the bar exam chooses to test you on and for you to make arguments on behalf of the defendant, on behalf of the prosecution, and argue both ways. Let's take another crime. Burglary is another option that we might have. We learn common law burglary, breaking and entering of a dwelling house of another at nighttime, another specific intent element with the intent to commit a crime therein. You got to memorize that. You got to understand common law burglary. You have to understand the common law elements. And you have to understand it for the purpose of evaluating it for the professor's exam, for the bar exam. Well, I can make some different choices with respect to this. Maybe, some of these elements are quite frankly pretty dated. The idea that it's at nighttime or the dwelling house of another don't make a whole lot of sense. So I might make a choice to drop one of them. I might drop the whole nighttime thing. It doesn't make its way into a lot of modern statutes. I'll drop it for mine. I might drop the dwelling house of another. It doesn't really need to be a dwelling. Instead, so one I'll drop entirely, the nighttime requirement. The other one I'll sort of redefine a structure, whether commercial or residential, belonging to another. Similar, draws upon it. It's kind of like it, but it's different from the common law. And I'll incorporate that specific intent element of with intent to commit a crime therein. So my burglary statute, the Porter Penal Code, the whatever made up jurisdiction I am in and whatever statute I'm crafting on behalf of that jurisdiction draws directly from the common law. I take breaking and entering, I tweak the dwelling house of another to mean a structure that's commercial or residential, and I keep that same specific intent element. So a long way of saying it draws directly from the common law. I'm writing a statute that is directly from the common law. Another good example comes from, common law murder. Common law murder, no degrees. They just had a definition developed for common law murder, and that was the unlawful killing of another human being with malice aforethought. And we learned from the development of case law over years, the common law incorporated several different intents, 4 different types of intent that meant malice aforethought: intent to kill, intent to cause grievous bodily injury, depraved heart, or the felony murder rule. Okay, so we have these developments. So as we know, every jurisdiction has a statute. As the test giver, the bar exam, or your professor, they're going to have a fake statute. They're going to have, in my case, Porter's Penal Code, the PPC, and the PPC is going to draw from this understanding, draw from your understanding of murder, and most specifically the developed malice aforethought definition. And I'm going to make some choices. First choice I'm going to make is I'm going to have some different degrees. I'm going to have a first degree, I'm going to have a second degree murder, and I'm going to choose essentially what's worse. What's a killing that's worse, and I'm going to make that first degree, and I'm going to have the punishment go along with that, and then I'll have a second degree murder. So for first degree murder, I want to make some choices, and the choices that we learn about throughout the course, right? I have to have malice aforethought. I have to have one of these 4 things as part of it, but I also have to have something extra. We read some cases about deliberate, willful, and premeditated, And specifically, those cases explain to us that in order to be deliberate, in order to be premeditated, it has to be something beyond just the mere intent to kill. It can't just be common law murder. It has to be common law murder, the intent to kill, plus what it means to deliberate and think about something and the choices of our actions, plus premeditated to think about it beforehand in some way and plan it out in some way. The other popular one is there's certain manners of killing. I might have poison or destructive device or murder for hire, any number of certain manners of killing that I can put into my first degree murder statute that I'm testing you on for the exam. And then lastly, I might pick a popular one is I might pick the understanding of the felony murder rule might move over, but I'm going to pick my certain underlying felonies. So you have to know what felony murder is. You have to know what it's about. You have to know the whole part about the expanded timeline. It includes attempts, it includes some of the pregame, includes in furtherance or flight from some of the postgame. But the certain felonies, I might pick kidnapping and burglary, and I might pick robbery, and I might pick, escape, and these types of underlying felonies, and say, yeah, those are going to be the types of felony murder, the types of underlying felonies to the felony murder, that I'm particularly concerned about. So those are going to go into my first degree statute. So I draw upon not only malice aforethought because it forms the baseline, these are still crimes committed with malice aforethought, but there's some additives. There's the deliberate, willful, premeditated, there's certain manners of killing, there's certain underlying felonies that add on top of my felony murder statute. So my choice for my statute, particularly murder one, draws upon my understanding of common law murder, draws upon my understanding of the term of art of malice aforethought that helps define common law murder. Why do you have to know it? Because everything about our understanding of murder and common law murder, translates into how I craft my statute, particularly my first degree murder statute. And then look at second degree murder. Yeah, I'm bringing over the same malice aforethought decision. Maybe I don't like the grievous bodily injury part, so I bring over intent to kill, I bring over depraved heart, and then I bring over some sort of, catch-all to my felony murder rule, right? We know we studied California. They do something like this with Section 189. So their felony murder rule in murder two is essentially all other felonies. They've listed out the ones they like, just like I did on the previous slide, of the underlying felonies that represent first degree. All the other felonies, represent second degree and are part of the malice aforethought decision. Well, we know what that means. We're going to need some of those limitations. In addition to the expanded timeline of some of the attempts and pregame stuff and some of the in furtherance and flight from and the postgame stuff, we need some of the limitations. Like it has to be an inherently dangerous felony. It has to, not merge. It has to be sufficiently independent from the underlying felony. And it has to be, an agency versus proximate cause theory, other limitations. So, all of our understanding, all of our case law, everything goes into my choice for the Porter's Penal Code, the PPC, of how I'm defining malice in the second degree, how I'm defining murder in the second degree, incorporating parts of the malice aforethought decision that we covered as part of common law murder. And then we look at kind of the last thing that I have for you is voluntary manslaughter. There's some choices that we have to make here. Yeah, it's murder. It's with malice aforethought. It's some of what we just covered. And at common law, that murder was mitigated to manslaughter with what's called a heat of passion defense, adequate provocation, followed by the actions happened while the defendant was under the heat of passion. There wasn't sufficient time to cool down. Okay, we understand that from common law. We also understand, we learned something else. So we covered a statute that happened in the Model Penal Code. So some jurisdictions, including the Model Penal Code, just started to say, instead of the heat of passion defense, we have something called diminished capacity, or at the time of the killing, the defendant was operating under an extreme emotional disturbance. So our study of a statute, our study of the Model Penal Code in this instance, provided the professor or the bar exam an option as to how do they define their statute, how do they define their voluntary manslaughter on game day, on your exam day. And look, I made a choice. I have the murder with malice aforethought. That's my murder in the second degree. That's something we just talked about in the last slide. But I'm making the choice. I'm going to follow the Model Penal Code. I'm going to follow extreme emotional disturbance. I think that makes sense. And just think about it. You can imagine it being sort of a two-part question. how would this shake out? How would your arguments for the prosecution and defense come come forward if you were arguing under my statute, under the PPC here that incorporates extreme emotional disturbance to mitigate a crime from murder down to manslaughter? But you could also have a follow-on question that says, okay, what if it were common law? How would it be different? Because the heat of passion is different in requiring adequate provocation, requiring heat of passion, as opposed to just looking at the defendant themselves and saying, were they acting at that time under extreme emotional disturbance? So it's choices that the test taker, it's choices that the test giver gets to hand out and gets to make, and that reflect on your understanding. So you had to understand murder, you had to understand common law murder, you had to understand malice aforethought as part of that definition, and you had to understand some of the options available to the jurisdiction as to how one might mitigate murder down to manslaughter. Could use the common law with heat of passion, adequate provocation, but I could also use what shows up in a lot of statutes, including the Model Penal Code of extreme emotional disturbance. So my choice for your exam might do what happens in the right. I might pick one or the other, and that's what you have to apply. Make arguments for the prosecution, make arguments for the defense. Hopefully that helps some of the decisions that we make. Like larceny, I took the whole common law statute, I made it my statute. For burglary, I took parts of the common law statute and I rewrote some and dropped some others. I dropped nighttime, but I rewrote the dwelling house of another, but I kept the all-important specific intent element. Then we went to my murder statute. We looked at common law murder and specifically the definition of malice aforethought, and I brought some elements of it over as a baseline, but then add some additional things like deliberate and willful and premeditated. That's part of what I added. I added certain manners of killing. And then I picked certain underlying felonies that would incorporate my felony murder doctrine and made it murder one. That's how I crafted my statute. Those are the choices I made for my statute that you have to apply. And then if you proceed to my murder two, it was more of a catch-all. It was any other unlawful killing of another person with malice aforethought. And that incorporates, the rest of the felony murder doctrine and some of the other parts of malice aforethought. And then here in the slide that we land on, we're talking about, what I do with my voluntary manslaughter statute. I have choices. I have choices in the way statutes have sort of deviated from common law because of some of the problems associated with it. So I might have a murder statute like I did in the previous slides. And how does it mitigate to manslaughter, voluntary manslaughter in particular? Could be a heat of passion defense, adequate provocation under common law, or it could be extreme emotional disturbance under a bunch of statutes, but as demonstrated by the Model Penal Code. Here, I chose to have my mitigation from murder to manslaughter be the extreme emotional disturbance, and that was the choice I made for the statute. That's what you'd have to apply. So we make lots of choices, all drawing upon common law, all drawing upon some of the examples that we see. Quite frankly, most of the time in the course, I'm showing you examples in statutes that draw directly from common law. I'm showing you the word malice aforethought as it shows up in half a dozen murder statutes in different penal codes. Why? Because that term, the reason why you have to learn it, the reason why it's part of our studies, is because it shows up all over the place in current penal codes, and we have to interpret it as prior courts did, developing that common law statute. Hope this helps.